Okay, so let's jump right into it kasi nakapagkape na tayo. Okay, mistake of fact. Mistake of fact is the misapprehension of facts by the accused which, if true, would justify, meaning walang criminal liability, would justify the act or omission committed. It is a defense and an absolutory cause because such person is not criminally liable for lack of criminal intent. So, mali ang appreciation of facts or ng circumstance ng offender. Pero yung pag-appreciate niya ng facts or circumstances made in good faith. Na talaga naman na kung dyan ka sa posisyon niya, iisipin mo yon. And nag-react yung offender based doon, which is lawful yung reaction niya and made with due care. Kaya wala siyang liability kasi wala siyang criminal intent. Although, diba kanina, criminal intent is an element in dolo pero hindi in culpa. Pero pag culpa, may liability pa rin. Walang mistake of fact pag negligence. Dapat criminal intent. Kasi kapag may negligence, may kakulangan pa din. Dito kasi, walang kakulangan. It's just that any person in that position would react that way. Na hindi careless. Na yun talaga yung dapat gawin sa sitwasyong yun. Yun yung mistake of fact. And later we will discuss the landmark case of US versus Achong. So first requisites of mistake of fact para mas maintindihan natin. The accused has the burden of proving. So si accused yung may burden to prove because siya yung nag-i-invoke as a defense. The act would have been lawful had the facts been what the accused believed them to be. Second, the intention of the accused in performing the act must be lawful. And lastly, that the act must not be attended with fault or carelessness on the part of the accused. So, yung action niya dapat honest and a reasonable mistake, and it must be a matter of fact, and that it negates the culpability. Again, yung negligence, yung imprudence, yung lack of foresight, lack of skill, walang ganon. It negates the culpability required to commit the crime or the existence of the mental state which the statute prescribes with respect to an element of the offense, and there is absence of intent. If there is mistake of fact, absence of intent. Yun yung nagpapa-justify sa kanya. Criminal intent is one of the elements, again, of crimes by dolo. Iba yung mistake of fact sa mistake of law. Kasi yung mistake of law, yung apply nating principle dito is ignorancia something. I wanted to cite this Spanish, but ignorance of the law excuses no one. Yun, English na lang tayo. Mistake of law kasi is the want of knowledge or acquaintance with the laws of the land insofar as they apply to the act, relation, duty, or matter under consideration. And it is not an absolutory cause and cannot be used as a defense. So again, mistake of fact, okay. Mistake of law, no. Okay, so US versus Achong. Hindi ka pwedeng gumraduate sa law school na hindi mo alam yung US versus Achong. No? So si Achong kasi, basically, nagtatrabaho siya sa, nakalimutan ko, parang sa kampo, parang ganon, parang cook siya doon. Tapos, nung time na yon, very rampant yung robberies. So, delikado, diba? Kaya yung ginawa nila ng roommate niya, talagang sinecure yung room nila. Nilagyan ng parang barricade, tapos si Achong naman may natutulog na may katabing weapon. Like, I think it was a knife. No? Tapos, iyon, may roommate siya. Yung roommate niya, late na nakauwi. Tulog na si Achong nun. Tapos, may naririnig siyang parang nagtatry na buksan yung door. And, he called twice yata. Na sinabi niya, sino yan? Ganyan. Hindi sumasagot. Tapos, ayun, parang yung circumstances was madilim. Uso yung nakawan. And yung mga akyat bahay. Tapos, ang gabi na, merong gumagano, may nagfo-force open ng door. Hindi man lang yung parang katok, hindi rin sumasagot pag tinatanong kung sino. Hindi nagsasalita. So, si Achong yung knife na nasa tabi niya, pag matutulog siya, as defense, he took it, and then, nung pumasok yung tao na nagtatry i-open yung door, nung pumasok, sinaksak niya. Ang dilim ng time na yun, may mga vine pa rin sa window nila. So, ganon. Akala niya magnanakaw, so sinaksak niya. And apparently namatay, yun pala nalaman niya roommate niya yun. So, dito, there was a mistake of fact. Therefore, may criminal liability ba si Achong? Wala. Ganon. Read nyo na lang yung case if hindi nyo alam yung case, kasi landmark case to. Tapos kino-compare siya lagi sa People versus Owanis. Okay? Yung kay Owanis naman, merong wanted na criminal, tapos merong instruction from the chief of police na dapat mahuli tong criminal dead or alive. Parang ganon. So, yung ginawa nila Uwanis is hinanap nila, tapos nagkaroon sila ng intel. Tapos, pinasok nila yung bahay kung saan nandun daw yung suspetsado. Tapos, may natutulog doon. Binaril nila. Parang ganon. Tapos, sabi ng court dito, nag-invoke sila kasi na parang mistake of fact. Sabi ng court dito, hindi mistake of fact. It's just criminal negligence. Kasi, nakatalikod, natutulog, walang armas. Tapos kayo, police, may armas. Diba? Hindi nyo man lang verify kung sino yan. Pinaulanan nyo na agad ng bala or pinatay nyo na agad. So, parang hindi commensurate, kumbaga, and napaka-negligent. Again, hindi consistent yung culpability sa mistake of fact na pwedeng gamitin to justify, para walang to negate criminal liability. So, hindi siya applicable dito. Hindi pwedeng gamitin. Hindi nila pwedeng i-cite yung US versus Achong kasi different yung nangyari dito. Kay Achong kasi merong due care. Dito, negligent lang talaga sila sa duties nila. Okay. Aberratio Ictus naman is mistake of blow. So, pag mistake of blow, like for example, siya sana yung gusto mong tamaan, but then, hindi mo siya natamaan, yung intended person mong tamaan, iba yung nadamay, iba yung natamaan. Still, liable yung offender kasi merong criminal intent dito. Kaso nga lang, iba yung nakatanggap sa inintend. But, that doesn't matter kasi, paano ba nagkaka-liability? If you commit a crime, diba, may intention ka to commit a crime and you actually did it, so tapos na lahat, wala na tayong pakisa kung sino exactly yung namatay or na-injure. The thing is, may effect siya, yung criminal act mo. Nagkaroon ng damage, nagkaroon ng injury, nagkaroon ng loss. Tapos, na-consummate na kumbaga yung elements nung crime. Hindi, wala naman sa elements na kailangan kung sino yung gusto mong patayin. Yun dapat yung mamamatay para maging liable ka. Hindi. So, yung Aberratio Ictus, hindi siya justifying. Okay. Praeter Intentionem naman, liable pa rin, pero mitigating. May gusto kang gawin, pero yung naging consequence niya is malala dun sa inintend mo. So, mitigating siya. Kasi, hindi naman ganun ka-perverse dapat yung pinlano niyang gawin eh. It's just that, it happened na mas malala yung consequence. Tinitigan ko sa notes ko ano yung mga importanteng i-share. So, attempting to commit suicide and killing someone else instead unintentionally does not commit a crime. So, attempting to commit suicide is not an intentional crime. Therefore, yung consequence noon kapag it's not a case of Praeter Intentionem. Walang criminal liability. So, gusto mong patayin yung sarili mo, pero iba yung namatay, hindi ka liable dun sa namatay dahil yung pagsusuicide, hindi naman siya criminal act. So, yung consequence niya, not arising from the criminal action, hindi mo mai-impute dun sa nag-act. Sa gustong mag-commit ng suicide. If someone fired a gun indiscriminately and a passerby was hit, such is a case of Praeter Intentionem. He's liable for homicide for the death of the passerby because discharge of firearm is an intentional crime. So, ito yung difference dun sa suicide. There is a law that amended the law on alarms and scandals that criminalizes discharge of firearm in a public place. So, the death of the passerby is a direct and logical consequence of his action, his criminal action of discharging the firearm. So, Praeter Intentionem siya. Gusto niya lang sana mag-commit ng Praeter Intentionem kaso naging homicide yung resulta. Still liable, pero appreciated as mitigating, meaning bawas yung penalty mo. A woman threw hot water to another woman but instead hit 2 children. The children suffered injuries. Is the woman liable? Yes. Because Praeter Intentionem pa rin siya. She's liable for RA 7610 for injuring the children even if it wasn't her intention, because when she threw hot water to another woman, she was already committing an intentional felony, which is physical injuries. So, she had to be made liable for all consequences. Praeter Intentionem applies not only to crimes under the RPC but also violations of special penal law. Nagkape na ako pero inaantok pa rin ako. Okay. Cause and effect relationship. There must be a relation of cause and effect, the cause being the felonious act of the offender and the effect being its logical consequence, which is the resulting crime. So, the cause and effect relationship is not altered, meaning meron pa ring liability, meron pa ring imputability. Yung mga enumerate ko, hindi to mga efficient intervening cause. So, kahit nag-exist yung mga to, liable pa din. So, yung mga to? First is the pathological condition of the victim. Second, the predisposition of the offended party or the victim. Then, the concomitant or concurrent conditions or other conditions supervening the felony, such as yung masakit like tetanus, pulmonary infection, or gangrene. Kasi bakit ka pa rin liable? Dahil meron ka talagang criminal mind. And kung meron man siyang precondition yung victim mo at hindi siya namatay dun sa blow that you inflicted if you are the offender, Shit, nantok na ako, di gumagana yung utak ko. Ayun nga, pa rin, inintend mo pa rin yung crime and inaccelerate mo lang. Like, hindi naman dapat, sure may precondition siya, pero kung hindi mo ginawa yun, hindi sana ma-accelerate or ma-aggravate yung sitwasyon niya. Diba? So, pinalala mo or minadali mo. Like, sure, may cancer, kunwari, at dying na. But then again, pinatay mo. So, hindi mo pwedeng sabihin na, kasi may cancer na din naman na siya, mamamatay na din naman na siya. Hindi. So, inaccelerate mo kung ano yung meron siya. Ikaw yung cause eh. Dapat mabubuhay pa yan eh. Pero, may ginawa kang crime, hindi mo pwedeng idahilan yung condition ng victim. So, yun. And then, let's discuss proximate cause. It is the cause which is in its natural and continuous sequence, unbroken by any efficient intervening cause, produces an injury without which the result would not have occurred. It is the causal connection between the felonious act and the resultant injury. So, yan. Kung ikaw pa rin yung proximate cause at walang efficient intervening cause na sobrang independent na whether or not ginawa mo yon, yung effect same pa din because of the efficient intervening cause. So, kunwari yung isang lalaki may sinuntok, tapos yung sinuntok nahulog and nabagok, liable ba yung sumuntok? The answer is yes, kasi yung pagsuntok it's a criminal act and namatay kasi siya dahil like nabagok siya, diba? Hindi naman yung mababagok kung hindi sinuntok. So yung suntok pa rin yung proximate cause. So ano pa? Kunwari naman yung tao sinaksak, tapos yung nagsaksak sa kanya hindi siya tinuluyan, na yung victim hindi namatay agad and nag-seek ng medical help and later namatay. Okay. So liable pa rin ba? Kasi like yung infection yung dahilan sasabihin, hindi, mali. Kasi hindi naman yan sana, okay, nag-ingat sana siya, pero dahil sa injury mo ayun tuloy namatay. So kung hindi mo siya sana sinaksak, hindi sana siya magkakaroon ng tetano or infection, diba? May case na ganito eh. So liable pa din. So what do we mean by efficient intervening cause? So efficient intervening cause is a circumstance that breaks the connection between the felonious act and the resultant injury. So the accused will not be liable for the criminal act here, but may or may not be liable for the result. So, kunwari, may nagsuntukan na naman. Tapos, yung sinuntok, biglang nakidlatan. So, namatay siya dahil dun sa kidlat. So, obviously, naging efficient intervening cause yung kidlat, yun na yung magiging parang proximate cause, hindi na ikaw na nag-commit ng crime. Corpus Delicti is the body or substance of the crime, and in its primary sense refers to the fact that the crime has actually been committed. As applied to a particular offense, it means the actual commission by someone of the particular crime charged. Corpus Delicti refers to the specific injury or loss sustained. So, yung corpus delicti, hindi yan yung body of the crime, yan yung parang subject. So, in its legal sense, corpus delicti, hindi yun yung body of the person who was murdered or yung firearms, hindi ganon. It's the corpus delicti here is the yung action, okay? yung action or omission. So, another is if kunwari illegal possession of firearms yung kaso, yung firearms, hindi yun yung corpus delicti. Yung corpus delicti sa case na to is the accused's lack of license or permit to carry such firearm. So, yan. Okay, tignan natin. Mga cases lang to. Okay, let's go to impossible crimes. And then, I don't know, let's probably call it a night. So, criminal liability is still incurred if the act would be a crime against persons or property were it not for the inherent impossibility of its accomplishment, which is the first kind of impossibility, or on account of the employment of inadequate and ineffectual means, which is the second kind. No person was killed or injured, no party was taken or damaged, but a person may still incur criminal liability. So, yung punishment natin for impossible crime, kahit walang saktan, no, is arresto mayor or fine or of not more than 500 pesos. Okay, the requisites of an impossible crime: that the act performed would be an offense against persons or property, that the act was done with evil intent, that its accomplishment was inherently impossible, or the means employed was, again yung second, is either inadequate or ineffectual means. So, yun. Ano ba itong mga impossibility na to? When you say inherent impossibility, the act intended by the offender is by its nature one of the impossible accomplishment. Okay. Yung nature mismo ng impossible. Legal impossibility naman, the intended acts, even if completed, do not amount to a crime. So if there is motive, desire, and expectation to perform an act in violation of the law, there is an intention to perform the physical act, there is a performance of the intended physical act, and the consequence resulting from such intended physical act does not amount to a crime. Yung physical impossibility naman from the word itself, extraneous circumstances unknown to the actor beyond his control prevent the consummation of the intended crime. So, no attempted or frustrated impossible crime, since the offender is an impossible crime has already performed the acts for the execution of the same, there could be no attempted impossible crime. There's no frustrated impossible crime either, because the acts performed by the offender are considered as constituting a consummated offense. Kasi ginawa mo na lahat pero it was just either legally impossible or physically impossible, kaya hindi nangyari. Okay. So, last topic for tonight, plurality. So, plurality of crimes consists of the successive execution by the same individual of different criminal acts upon which no conviction has yet been declared. There's plurality of crimes or concur de delito. Ang ganon. When the actor commits various delictual acts of the same or different kind or delicts. Ideal plurality, yung concurso, ideal occurs when a single act gives rise to various infractions of law. So, pwede siyang complex crime in Article 48, special complex crime, wherein nagpo-provide yung special penal law ng specific dyan kung paano i-deal yung plurality, and then continued or continuous crime. So, continued or continuous crime, maraming result pero isang single impulse lang. Yung continuing or transitory, again, it's more of a remedial law concept kung saan yung venue. Real plurality or concursorial arises when the accused performs an act or different acts with distinct purposes and resulting in different crimes which are judicially independent. So, compound crimes, only a single act is performed by the offender, pero maraming na-produce na crimes. Such as, merong grave felonies, or isa grave, isa less grave, or dalawang less grave, diba? Complex crime proper exists when the offense committed is a necessary means to committing another offense. So, ito yung complex. Pag kino-complex mo kasi, parang isa lang siyang impulse, pero, ayun nga, parang dalawang effect, pero it treat siya as one. Kaya meron tayong mga robbery with homicide, ganon. So, yun. Absorption rule can result to the greater crime absorbing the lesser crime, or vice versa. Composite or special complex crime. Okay. Continued or continuous, yung na-explain ko kanina, and continuing or transitory crime. One larceny doctrine for prosecution of theft cases. The one larceny doctrine. Kita tayo sa atin yung reviewer. Provides that the taking of several things, whether belong to the same or different owners, at the same time and place, constitutes one larceny only so long as there is a single criminal impulse. Alright. So, ayun. Maraming magagandang kaso dito, pero pagod na ako. Like, Intod versus CA. Important yan. Urbano versus IAC. Yes, also. Ganon. Ano pa? Ayun. Yun yung mga need basahin, of course. Pati US versus ACHO. Okay, see you next time. Bye!